Good morning, all of you. Am I audible to you? Am I audible to you? Hello? Okay, thank you. Okay, till the last session, we are trying to cover the zero stage of criminal session. Apart from that, we've gone through the important parts that we can say it as a types of offenses on the basis of cognizable offense and non-cognizable offense, bailable offense and non-bailable offense, compoundable offense and non-compoundable offense. And apart from that, serious offense and non-serious offense. All these parts we gone through. Then after we will move towards the next part that we can see at the first schedule of CRPC. In the first schedule of CRPC, we learn something new in which we have some ready-made chart from the CRPC, and that ready-made chart is going to show us the different kind of aspect regarding the IPC section, offense definition, particular punishment of that offense. Then the fourth column is regarding the whether that offense or the crime is cognizable or non-cognizable, whether that crime is bailable or non-bailable, whether in which particular court the crime is going to trial. So these kind of things are there. We gone through in the first schedule of CRPC. In the very next part to the CRPC first schedule, we have to learn section 320 of CRPC, in which 320 section of CRPC we learn the compoundable offense and non-compoundable offense. Compoundable offense means if any victim due to any some reason, if his thing is so he have to compromise with the accused or the offender, then he can compromise. And the complaint which is registered against the accused might be few section of that discharge over there, or all the section were discharged over there. So many things are there apart from that. This will be the first instance in which if victim is going to compromise with the opponent party or the accused, and in the next part, even if victim is going to compromise with the opponent party, but even though that person, or in this particular case, there is some requirement of court's permission to compromise within the case. So all these parts are there regarding the compoundable and non-compoundable offense. That will be there in section 320 of CRPC. In the next part, we have to learn now how the case is going to proceed in the court of law. Whenever any crime or the zero stage or the offense will be happen, the information of offense will receive towards the police station. So let me share you this screen. So we'll continue with all this part. Okay, allow me 1 minute. So I'm just sharing you this screen. Suppose this kind of crime is there in particular area. So whenever any crime will be happen in particular area, there is some kind of sort of information should be there. Once any crime will be done, the information of crime we have to convey towards the authorities which are going to deal with this particular crime, means the police station and all. Whenever any crime will be done, apart from whatever the crime of it is, whether it is bailable offense, non-bailable offense, whether that crime is compoundable, non-compoundable, whether that crime is serious or non-serious, or whether that crime is cognizable or non-cognizable, there should be convey a particular message towards the police station. Otherwise, there is no any hint to the police station regarding that particular crime. Then there is no any use of police officer or the police station if any information is not conveyed towards the police station. So whenever any crime will be there, we should have to convey that particular information towards the police station, and then they will start the investigating the matter, and the procedure will be going on for the criminal cases. So in this particular scenario, whatever the kind of information we have to convey regarding that particular crime, it will be conveyed in the form of some sort of situations. If any victim is going to provide the information, otherwise the next part will be happen. If any family member of victim is going to convey the information, or the relatives of victim, or the any informant, that we can say it as in local language khabri, any gunda type of person who is an informant of police wala, so this person is going to convey the information. If any police wala is also convey the information to the police station. If any third party or due to sort of information from the court, many times court is going to take the cognizance of any crime or the offense through newspaper or any kind of sort of information received to the court. So they are just convey that particular message to the competent police station, and then police wala is going to continue with the procedure of criminal thing. Then after any third party or any common person, any friend of victim, any government officials, any news or the social media or the TV media or the radio, whatever the kind of situation, means once the crime will be done, we should have to convey that particular information to the police station in the form of oral way, in the form of written way, in the form of videography, audiography, social media, or the calling, or the any third party medium. Like you have to do the WhatsApp over there, you have to do such a kind of information through the online complaint, or through email, or any suitable medium that fits to you. There is no any restriction to convey the information is only particular kind of form. No. If there is such a kind of crime and you have to convey that particular message, you can convey in any way. But it is duty of police wala to cross check what kind of information received to them. Then they have to take action against them. So this will be the part for the same. But whatever the lists are there, any kind of medium we can use to convey that particular crime information to the police wala, and likewise all this information whenever police wala receive. So in general, whenever this kind of information received to the police wala, it is there in the form of two basic part. The first part is regarding the FIR, that we can say it as a first information report, and the second part is regarding the non-cognizable report, that we can say it as a NCR. So in these two form, in general, information received to the police wala might be in the oral form, written form, videography, audiography, social media, calling, or the WhatsApp, or the email, or any convenient medium. So this kind of things are there to convey the information to the police wala to start the investigating the matter. Okay, so this was the part regarding the same. Whenever police wala receive such a kind of information regarding that particular crime. So many times what happened, the police wala are not going to rely on your information. Many times due to some political reason, they are not going to go through all this situation. Might be they are having some pressure regarding the political things, or the if any influential person is involved in that particular case. Many times there are delay notice in that particular complaint. Many times there are some burden on the victim or the witnesses or the informant. Many things are there in this parallel way. But if any information received with the police wala, and if they are insufficient or they are not convenient to register the complaint over there, then CRPC is giving us option regarding if police station or the police authorities are not going to take any kind of action or registering the complaint of you, then you have an option to write down one of the letter or the application or the complaint in the written form to the head of police station in charge of that particular area, means SP or the superintendent of police of that particular area. You have to send that particular complaint or the application towards the SP of that particular area, and you have to inform regarding that particular complaint. If any evidences are there, you have to attach the copy of particular things. And likewise, if police wala are not going to register your complaint, you just have to surpass all these things and you directly have to visit the office of superintendent of police, and you have to convey the information regarding the particular crime. If SP of that particular area, even though he is competent to register the complaint or the instruct the police wala to register the complaint, as we think it so that SP is doing his tremendous work and he instruct the police station after receiving your complaint in the written form with some evidences and all, then police wala have to have, or the local police station have to have registered the complaint of that particular victim or the complainant or the informant, and they have to start the investigation within the matter. But even though in this particular scenario, if that SP or the superintendent of police is not going to instruct the police wala, might be there is some reason, might be there is some influential person is involved or the political person is involved or the any third party reason, and even though due to some such a kind of reason, if SP of that particular police area is not going to even instruct the police wala and is not convinced to register the complaint of that victim or the informant or the complainant, then the last opportunity you having as a victim or the informant or the complainant, you just have to write it down one of the application, or you directly visit the particular jurisdictions magistrate over there, and you have to inform the particular magistrate regarding that crime in the form of oral way or in the form of written way, is totally depending on what court think fit so for the suitability of that particular case. If court think fit so, you have written something kind of application towards the magistrate, then court is going to cross check whether you are correct or not. If any evidences courts want to cross check, they will cross check that. If courts want to cross check your witnesses, then that things also happen. And once the particular court or the magistrate is in opinion what kind of information received to them in the form of complaint, if they think fit so that information is correct, Then in this particular situation, court is going to give the instruct the police station, local police station, to investigate in the particular matter, and the matter will be registered as a private complaint in the court of law, and the procedure will be done. Many times, if any person who is a complainant, informant, or the victim, he's not that much of aware about how to write the application and all, and in this particular situation, the court is going to register the complaint or the take the cognizance of that particular complaint, even though that victim or the informant or the complainant is giving or convey the information in the oral way. It totally depending on the discretionary power of particular court. So these kind of situations are there in the parallel way. Means if I have to convey the message of any complaint to the police station is not going to register the complaint, then I have an option to move the written application towards the SP of that particular area. If FC is supposed to take the strict action against that particular case, if he is also incompetent for the same, then we have an option to move the private complaint application towards the magistrate of that particular jurisdiction. So all these things are there regarding the convey the message of particular things or the crime. If that magistrate court is not even competent for the same, then we have another option to gain the cognizance of higher courts, to do such a kind of publicity stunt via news media or the social media. So many options are there. So these are the things via we can convey our message of crime towards the police station. So all these things are there regarding the same. So we can go through the same one by one. But before moving towards the same part, we have to learn in few seconds regarding the particular kind of courts are involved in the criminal procedure code. So likewise, as we gone through the civil things, in which we learn there are some sub-district, tehsil, mandal or the taluka level courts. In the upper hand to that, district level courts, then after high court level, state level court, or then after national level court, that we can say it as a Supreme Court. Likewise, in the criminal things, the kind of courts established in the taluka, tehsil, mandal level or the tehsil level or the sub-district level are the magistrate court. The higher magistrate, we can say it as a chief judicial magistrate. He is having some kind of power to procedure with the cases in which they are having some power to hear the matter which having the involvement of 3 to 7 years of punishment or the any kind of fine according to the law. But all such a things are differ with state to state, means such a kind of information is not applicable to the state of Maharashtra, but in any particular courts depending on the scenario. So the power of chief judicial magistrate or the other kind of courts are totally differ with the particular area or state to state. So but we are just taking the example at the sub district level, taluka, tehsil, mandal level, magistrate court are established. The main magistrate court or the higher magistrate court is chief judicial magistrate, and apart from that, the inherent power will be there to the first class magistrate and second class magistrate, and likewise the different kind of powers we are giving to the particular kind of subordinate courts, that we can say it as the first class judicial magistrate, second class judicial magistrate, and the higher to that chief judicial magistrate. Many times number of magistrate list will be there due to the increasing number of cases, means number of first class judicial magistrate will be there, number of second class judicial magistrate will be there. In many states, only first class magistrate are established. There is no any such a kind of second class magistrate. So it totally depending on in which state you are there. Then after the particular things, apart from that, at the district level, we can notice session court is established over there, and in the session court, we are look forward towards the session judge. Apart from that, additional session judges are there, assistant session judges are there, and particular kind of powers we are just giving to this kind of such a courts at a district level. Apart from the such a kind of situation, session court or the session judge or the additional session judge having a power to give the death penalty in that crime if there is some such a kind of crime which is serious in nature. Then court having a power to punish that particular accused or the offender for the life imprisonment or for the death penalty, and in the form of death penalty, that session court have to have convey the message in the written form or have to have convey the report of that particular death penalty along with the all such evidences by which that particular session judge or the particular additional session judge is think fit so why there should be a death penalty to that particular accused. And likewise, such a information we have to convey to the particular state government, not particular state government, but the high court of that particular state. And in that particular high court, might be there are some commissions of judges, and they are going to cross check each and everything by what reason that particular court is convinced to punish as a death penalty. Once the high court is convinced at the same, the punishment will be continued as a death penalty. But court think fit so, high court think fit so, there is no any reason to continue with the death penalty because due to some influence that session judge or the additional session judge done with this kind of punishment, or by emotional point of view they just done with the death penalty, or due to the pressure of the society or the influential person, court done the job to do the death penalty. And in this particular scenario, high court is going to ask the session judge or the additional session judge regarding the show cause action or the show cause notice to the particular judges, and asking for what are the sufficient reason to continue with this death penalty. Is there any sufficient reason? If session judge or additional session judge are incompetent to convince the high court, then in this particular scenario, high court is going to cancel the particular penalty or the death penalty, and might be court think fit so court is going to transfer the matter to the another judges or the another area, or court is going to look after in that particular matter or the hearing. So totally depending on what kind of situation it is. Likewise, such a kind of informations are there for the jurisdiction purpose, for the district level or the taluka tehsil mandal level. If you are staying in any kind of metro cities means any city having a population more than 10 lakhs, and with the recommendation of high court or the session court of that particular area to the particular state government, if particular state government is convinced for the same to establish the metropolitan magistrate, then court is going or the judicial commission is instruct the state government to establish metropolitan magistrate in particular area which having a population of more than 10 lakh rupees, and that is why in that particular metro city we are going to establish the lower court as a taluka, tehsil, mandal or sub district level courts as a metropolitan magistrate court. The same power which are having to the taluka, tehsil, mandal level magistrate courts, likewise judicial magistrate court, in which chief judicial magistrate, first class judicial, second class judicial, likewise same powers are there to the metropolitan magistrate, and we can say it as a the higher will be there for the chief metropolitan magistrate. Apart from that, the subordinate courts are regarding the additional metropolitan magistrate and assistant metropolitan magistrate, and the same power which are lies with the chief judicial magistrate, first class judicial magistrate, second class judicial magistrate, are same power are transferred towards the this kind of metropolitan magistrate, in which will in which chief metropolitan magistrates are there, additional metropolitan magistrate and assistant metropolitan magistrate. So this will be the part for the ordinary general cities and the metropolitan cities, and this is the situation for the jurisdiction in the criminal courts. Apart from that, some kind of sort of special courts are to establish to done with the particular kind of special cases, but we will look after that after some time. Apart from the same things, after the session court, high court are also having a power to hear the matter in the form of appeal or in the form of original jurisdiction. If any case is there in the high court with the appeal from the lower courts, then we can say it as a high court having a appellate jurisdiction. If any case directly goes towards the high court due to the cognizance of high court, due to the cognizance of state government or the central government or the supreme court, then high court is going to take the cognizance of any case, or high court is going to personally involve in the procedure of particular case, which is going to note it down the report of that particular case. So many things are there. But if any information received to the high court from the supreme court, central government, special authorities, special investigation authorities, or the state government or the high court itself think fit so to look after the particular crime or to take the cognizance, then they can take the cognizance and the original jurisdiction of the criminal things will be done with the high court. Otherwise, high court having a power to hear the appellate cases from the criminal point of view. So all these things are there regarding the same in the hierarchy of the same. Then after higher court will be there to the all high courts are from the state. That we can say it as a Supreme Court, and Supreme Court are also having a power of appellate jurisdiction or the original jurisdiction. In the form of original jurisdiction in the High Court and the Supreme Court, first situation is like there is some issues regarding the fundamental things or the directive principles are there which are ruled by the Constitution of India. If they are violated of any person fundamental rights or the directive principle, then High Court or the Supreme Court are directly go through that particular cases as a writ petition, special leave petition, or the public interest litigation, depending on the scenario. Apart from the next thing is that if any things which is belonging to interpretation of statutes, means if any act or the rules or the regulation are done by the state government or the central government and if any inconvenience or the insufficient description is there, then the due procedure of law or the application from the subordinate court or the any either parties, high court or the supreme court are going to review that particular acts or the rules or regulation made by the state government or the act passed by the state government or the supreme or the parliament of the central government. Then in this particular things, court is also having a original jurisdiction to hear the matter and to decide the matter. So such a kind of information is there. In jurisdiction of Supreme Court and High Court. So this kind of general information you should have to keep in your mind in the criminal part. Apart from the same, whenever such a kind of information received to the police station, then in this particular scenario, police wala have to take this strict action against that particular crime whenever they will receive the crime from any competent medium, from the SP, from the victim, family member, relatives, informant, police wala, third party, court, common man or the friend or the government or the news or the social media in the form of oral, written, video, audiography, social media, calling, email, WhatsApp, or any particular option to convey the medium of information. Then police wala have to take this strict action against that particular crime, means they have to initiate the investigation in that particular crime. If any cognizable offense will be there, they can take the action or initiate the investigation without any prior permission from the court, the magistrate, or if any non-cognizable offense will be there, they have to take the permission of the court to start the investigation in that particular matter. Now in the very next part, we have to learn what is the FIR and NCR. So we'll go through the same chart one by one, in which we have to go through the particular blank form of FIR. I'm just pulling it down. You just have to read. We don't have to do that much of deeper thing. This kind of FIR is there: police stations information, sections information, crime information, type of information, distance from that particular crime to the police station, complainant's information, opponent party's information. All such a things are there. Apart from that, if any property is attached in that particular complaint, that information, inquest report or the Panchanamas information, or the FIR content or the story of that FIR. Likewise, such information. Then after, whoever the competent police authorities are there, or the stamp of that particular police station, and the signature of particular complainant or the victim or the informant. All kind of basic information is there for the FIR. Next information is regarding the NCR. Similar types of information is there in the non-cognizable report also. I am just scrolling it down. You just have to note all the points. So such a kind of information is there in the form of FIR and NCR. And once the police wala receives such a kind of information, they have to start the investigation within that particular matter. And if that police wala thinks it's so, they have to arrest any person, then they can arrest any person. And after the arrest of any person who is the suspected person or the accused or the offender person, then after the arrest or before the arrest, there are sort of some kind of powers or the rights of that particular accused or the person who is going to arrest by the police wala in the criminal cases, likewise they should have to write to get the knowledge of reason of arrest, consult with the likewise advocates over there, or the like-minded advocates, inform the relatives or the family members regarding the arrest. Other many more powers are there. If any ladies are there, we cannot arrest her after the sunset or before the sunrise. Many things are there. Whenever that lady is going to arrest, there should be presence of lady officers or the havaldars. After the arrest, there should be some kind of sort of medical examination from the government hospital. At the time of arrest, whatever the kind of devices or the things are there in custody of that accused or the suspected person, that should have to make a note of that. If any mobile phone, if any newspaper or the documents are attached from that particular accused or the suspected person, it's a duty of police wala to note it down all these things, and likewise that person will be arrested. If any person is arrested in any kind of case due to the permission of court or without permission of the court, police wala are doing the investigation and even arrest of that particular person. And after the arrest, under Article 21 of Constitution of India is saying every person having a right of life with their choice, whether they want to eat something they can eat, whether they have to read something they can read, they have to breathe something they can breathe, they have to visit something they can visit, they have to choose the profession of something they can choose. Likewise many things are there under Article 21, but right to life is the important part after the arrest, because after the arrest the major right of that particular victim or the suspected person is violate against the Constitution of India. That is why whoever the person who is arrested over there by the police wala or by the information received from the session court or the magistrate court to the session judge or the magistrate judge, they have to start the investigation within the matter. And once any person is going to arrest by the police wala, there are some sort of information is there. If once the person will be arrested, we should have to grant him bail. And likewise, if person is arrested, that person having a right to apply for the bail application, and in the bail application form there are some sort of information we should have to go through the same scenario. Likewise, there are some sort of information regarding the bail application. One is regular bail application and the second is anticipatory bail application. Regular bail application means any sort of bail application that accused or the suspected person is going to proceed before the courts, in which person is already arrested, and then after for release from that arrest, complainant are moving the application for the bail, then we can say it as a bail application or the regular bail application in cognizable offense or the non-cognizable offense, or in bailable offense and non-bailable offense. For the bailable offense, there is some section 436. For the non-bailable offense, section 437. And the next part is regarding the anticipatory bail application. Means if any person having a doubt, police wala are going to arrest him in the non-bailable offense or the serious kind of offense, then that person is going to file the anticipatory bail application in the session court, or after rejecting from the session court to the high court. So this kind of two situations are there. Regular bail application means after the arrest he is going to give the bail application for the release, and before the arrest, if he thinks it so, he's gonna arrest by the police wala, and if there's some violation of Article 21 of his, so he will move the application of anticipatory bail. So likewise, this information is there for the sort of things, and in this particular bail application, it is there for the conditions bail or without condition bails. In condition, many kind of conditions are there. Regularly visit the police wala or the court, or support in investigation. We have to submit our passport. We can't travel out of the India or the foreign countries or the foreign state. We can't visit the crime scene or the crime spot. We can't try to make the contact with victim or the witnesses. Many things are there in the condition, but totally depending on case to case. After the same sort of information is done regarding the bail, if we'll directly go through the simple format of bail application for regular or the anticipatory bail. Bail application's name is there, title clause will be there, parties information will be there. Then after the title of application is there, application under section so and so for the regular bail or the anticipatory bail. Then after this kind of such a sort of application is there for the bail, I'm just scroll it down. We don't have to go that much of this. If you attended all the session, it will be a part of your notes, so you can go through the same afterwards also. So such a kind of information is there for the bail. Then after the prayer clause will be there. So all things are there as a bail application. So bail application means for the temporary type of release to the accused or the suspected person, because in the bailable offense it is a right of offender or the accused or the suspected person, but in the non-bailable offense it is a matter of procedure, and there is no any right, but court thinks it so, then that person will be released. For the bail purpose, we have to proceed with such a kind of information to convey the bail bond or the surety. Bail bond means few or the sort of money or the monetary purpose or the monetary things we have to deposit in the court of law for the bail, to grant the bail, and after finishing of case, if you discharge from that particular time, then that money you can withdraw from that particular bail bond as a bail bond. You have to move the application to receive that particular bail bond amount, and like the similar things will be there. Apart from that, you have to convey the court to get the bail on the behalf of, to give the information of sureties. If any person is going to take the guarantee of you, then you will be released by giving the surety. Or in many cases, we also have to produce surety or the bail bond. In many cases, there is no any compulsion on the bail bond or the surety, depending on the scenario. Likewise, this is the kind of bail application. Whenever a person will be arrested, he is having a right to get the temporary type of sort of release during this pendency of the case. Likewise, in the next part, if any person is accused over there or convicted in any sort of case, and that person having some good kind of behavior with the jail staff or with the another colleague members, due to his behavior or any sort of reason, court thinks it so, after the conviction of it, after the trial, that person is supposed to also have to apply for the temporary kind of release as a parole. Means even though that person is convicted in any case, but he having option to get the temporary release, to visit the family or any kind of sort of things he can do with due permission of the court. He have to move the application for the parole. This is the first part. And the next part, after the conviction, if any person who is convicted for more than 5 years of imprisonment, then due to some good behavior or the maintaining peace in that particular jail or with the colleague members, state government is recommending that person regarding the furlough for the temporary release from that particular conviction. So both the things are also there. Bail is before the conviction, and after the conviction we have an option to go for the parole or go for the parole. Parole means you have to give the application, or the jailer is going to give the application parole on your behalf due to your good things or the good deeds, or in the parole is there in all sort of cases, but in the parole more than 5 years conviction should be there as a life not life, but more than 5 years conviction means it also including with the death penalty, it also including with the life imprisonment or sort of some serious kind of offences in which there is some more than 5 years of conviction is there or the punishment is there. So the state government is going to recommend the parole for that particular convicted person for the temporary purpose after the trial is done or after the conviction. So this is for the temporary release. Then after the next things is here. After all this kind of sort of information, if any person is registered with the FIR during the pendency of case, that accused or the offender or the suspected person is also have a right of choice to move the application in the High Court as a writ petition for the quashing of FIR. Quashing of FIR means the application to cancellation of FIR. If court thinks it so that is valid, then court is going to quashing the FIR means case will be dismissed. If court thinks it so there is no any reason to quash the FIR, then case will be continued. So such a kind of information you should have to keep in mind. Apart from the same point of view, there are some sort of information you should have to remember in the form of complaint. If any police wala is not going to register your FIR in many states or all the state having the power, in few kind of crime or the offences, you have an option to register the complaint through online platform or the official websites of FIR without visiting the police station, or in the second medium zero FIR concept is there, in which even though that person is or that crime spot is not having a jurisdiction to register the complaint, even though by the virtue of zero FIR we can easily register the complaint even though we don't have such a kind of jurisdiction. So this kind of sort of information you should have to keep in your mind. We don't have that much of time to go that much of deep in all this point, but all this information for the sake of it. After the registration of complaint, police wala have a right to start the investigation within that particular matter. Means whatever the police station is there is going to go through many things are there. They are going to cross check the complaint. They are going to proceed with the oppose the regular bail or the anticipatory bail. In the investigation, they have to collect the evidences, take the confession from the witnesses or the accused or the suspected person, do the panchanama or do the expert opinion. Likewise, whatever the sort of investigation they have to do. Regularly, they have to submit the report to the police station for the investigation, the status of investigation. In the murder case, they have to do the investigation in different way. In the sort of crime which are not that much of serious, in which they have to do the investigation in sort of different kind of things as the murder or the serious kind of offense. So such a kind of information is there. Panchanama means we can say it as an inquest report, which is the opinion of the senior person or the major person who is having some sort of information regarding that particular crime or the offense. Likewise, all this investigation is going to convey by the police wala, and time to time they have to give the status to the particular court. And after all this investigation, police wala have to conclude the investigation. During this investigation, many things will be there. They have to apply for the forensic department to cross check the evidences, to send the show cause notice to the different kind of person as a suspected person or for the investigation or as a witness. Many kind of things are there. To record the confession of accused, to record the confession of victim or the informant, depending on the scenario to scenario. So such a kind of information is there during the investigation, and any sort of information that correlate with the circumstantial evidences. We can't say police wala have to do all this investigation in particular manner only. Many times they have to correlate with the circumstances of that particular case. Means if any murder is there, they have to do the panchanama. They have to have convey for the postmortem, but it is not there in the theft things or the dagaili things or the kidnapping case, right? How we can ask for the postmortem in the kidnapping case if there is no any murder? So similar wise, whatever the investigation is here, it totally depending on the sort of crime. So all these things are there. Apart from the same, once the investigation will be done, police wala have to submit the charge sheet, means one of the report which giving the proper information to the court regarding that particular investigation. And with this charge sheet, police wala have to convey the message to that particular court, this is the sort of investigation we done, and because of this investigation you have to convict that particular accused through particular kind of punishment, for the rigorous punishment or the death penalty or the life imprisonment, whatever the kind of punishment is there, they have to convey the message to the police, to court. If we gone through the charge sheet wala part, I'm just scrolling it down, one of the format. Okay, this is one of the format for the charge sheet, in which investigation agency's name is there, case name is there, title of case, name of parties, then the FIR or the branch of investigations information is there, detailing of FIR, how the investigation is done, sort of sections, type of report, or the many sort of things are there. Accused information, complainant information, in detailing manner, all things are there. I'm just scrolling it down. Select it. Okay. So this is a kind of charge sheet which is filed by the police wala after the investigation is done. So many things are there in detail. What kind of investigation they done, what is the result of that, who is the accused, who is the suspected person, what are the witnesses, what the forensic report is saying, what the postmortem report is saying. So after the investigation, this kind of charge sheet police wala have to file before the court in detailed manner to convince the court to punish this particular offender or the accused. So this is the one of format for the charge sheet. So in this charge sheet, when police wala have to file the charge sheet after the arrest of any person, if any matter which is belonging to magistrate court, then within 60 days they have to file the charge sheet. In matter of session courts, 90 days or 60 days period is also there, lock-in period. But court can, with the investigation purpose, court can increase the time for the charge sheet, and many times it is moving on towards the taking some time for the filing the charge sheet. For 1 year or the 2 years or the 3 years. If there is no any such a kind of information received to the police wala even after the investigation in that particular matter, not from the forensic point of view, not from the general point of view, then police wala have to submit the closure report before the court by remark, we done the all kind of investigation, but there is no any traces of evidences, traces of accused or the suspected person. That is why we are suspecting, we are just submitting this kind of closure report, because there is no any use to waste the time in this investigation. So such a kind of sort of closure report filed by the police wala, if any, there is no any chance of sort of evidences they receive or the information of any informant or the accused or the suspected person received to them, then there is no any use of to waste time in the investigation. So such a kind of things are there apart from the investigation or file the charge sheet. So such a kind of things is there in the form of charge sheet. In the next part to that, if the charge sheet is filed by the police wala before the court. Court is going to give you the option to argue on the charge sheet. If any police wala are going to raise the question on the accused or the suspected person, then it is duty of court or the our procedure of law to give the information to the accused or the suspected person what kind of charges are there made by the police wala on his head, and that police wala or whatever the kind of accused or the suspected person will get the opportunity to argue on the charge sheet to inform the court there is only baseless information filed by the police wala in the charge sheet, and that is why you don't rely on that charge sheet. Likewise, accused is going to convince the court to discharge from all this charge sheet because of he having an opportunity to convey his message to the police wala or to the court. So likewise, charge sheet once the file, argument on charge sheet will be done first by the police authorities on the prosecution side, and after by the accused or the suspected side. Once the court is convinced on the both the opinion of prosecution side or the accused side or the offender side, court is going to finalize the charge. Means the charges are framed against the particular charges are final against the particular offender or the accused or the suspected person. Once court is rely on the point of view from the police wala or point of view from the accused side or the suspected side, the charges will be framed and court is going to hear the matter on the charges framed by the court or the charges are finalized by the court. Means many times during the investigation police wala are filed by their virtue of charge sheet. Likewise, 10 kind of offences are there reported by the police wala in charge sheet, but during this charge sheet argument court found that only 3 kind of sections are there or the crimes are there that should be the head of charge on this accused or the suspected person. Then court will rely on that and court is going to finalize the charges, and on that particular 3 or 4 points of section or the crime only the court is going to hear that particular matter. Apart from that, if police court think fit so, during the investigation, after the filing of charge sheet, after the argument on the charge sheet, court found that there is no any sort of evidence to prove the charge on that particular accused, then court is going to discharge that particular accused or the suspected person, because there is no any sort of investigation done properly manner or the even the investigation is done, there is no any evidences to prove the offense or the crime, then that person will be discharged from that particular case and case will be disposed of. If any person or if any court think fit so, after the argument on charge sheet, might be add some sort of charges or the different kind of section, or might be remove different kind of sections or the charges, or might be discharge all the case, or might be discharged from sort of sections, or might be go for the trial after the charge sheet or the finalization of charges. Likewise, all the parallel information is there for the same kind of view. After the charges are framed, if any accused think fit so, he won't receive or got the proper chance to representing himself in the argument, and whatever the head of charges are there on his head are not sufficient or there is some false information, then he will ask the court to review the matter or to approach the higher court to cross check the framing of charges, because he won't get the opportunity to hurt. That is why he also have an option during this charge sheet finalization or the argument on the charge sheet, or the after the finalization of charges, he will move the application to the higher courts for the same. So all these sort of informations are there, and higher court, whatever the convenience to them, if they will go for the same, then the case will be continued. If higher court thinks it so there is no any charge, then case will be discharged. So sort of informations are there, you have to keep in your mind. After the finalization of charges, the trial will be done. For the trial purpose, there are some sort of trials are there, but likewise, before moving the particular kind of types of trial, we should have to remember what is the trial means. Trial means now court having a sort of information from the point of view of police wala, for the point of view from the accused, but after the finalization of charges, court thinks it so only few sections are there, and that is why court is going to start the trial. And trial means whoever the complainant or the prosecution side, they have to convince the court by keeping all their evidences or the witnesses before the court, and court is going to cross check all these evidences, witnesses, opponent party is going to objection on that, and sort of things are recorded by the court, and likewise the first stage of trial will be done. In the second sort of trial, opponent party or the accused will get the opportunity to keep their evidences or the whatever the kind of information they are having, or they keep their witnesses before the court, and the prosecution side will get the opportunity to oppose all these evidences or the witnesses, or the sort of argument will be done, or the examination of accused, witnesses, or the evidences will be done. All these things we can say it as a trial. Means detailing, to collect the detailing of that particular crime or the offences, or after the finalization of charges regarding that particular sort of sections, to get the proper knowledge of crime in the form of evidences or the witnesses. So always such kind of information we can say it as a trial. And after the trial, we can say it as a not a trial. Okay, so after the sort of information, court is going to conclude with the evidences. Means both the evidences are closed by the prosecution side also and accused side also. Then argument will be done on the conclusion of evidences. Then after the argument, both the parties will get the opportunity to argue on the same, place their evidences, place their things, and after this sort of things, the judgment will be done in that particular criminal case. And after the judgment, you have an option. If you are convicted, you go for the appeal. If you are acquittal, opponent party will go for the appeal. So sort of information is there. These are the particular stages in the criminal trial. But in the same kind of criminal trial, if we let me go through the important part for the same. Wait a moment. Okay, during all this particular of things, there are a sort of kind of trials are there. One is regarding the session trial, one is regarding the warrant trial, one is regarding the summon trial, one is regarding the summary trial. session trial and warrant trial means all the investigation will be done, charge sheet is filed, and detailing of trial will be done. Likewise, in the case of death penalty, imprisonment for the life imprisonment or the imprisonment exceeding 2 years, in which kind of cases detailing of trial will be done, means accused will get opportunity, prosecution side will get opportunity, investigation will be done regarding the evidences, or the witnesses examination will be done, opponent party will get the equal opportunity to give the evidences, and the finalization of concluding of evidence and argument. So likewise, all this trial we can say it as a warrant trial, in which more than 2 years of imprisonment is there, then warrant trial will be done. And same kind of warrant trial will be done in the session court, we can say it as a session trial. And if next part is regarding the summon trial, means if any case in which less than 2 years of imprisonment is there, then summon trial will be done. And the next part is regarding the summary trial. It is a sort of speedy trial in which any kind of cases which having a less than 2 years of imprisonment but not a life imprisonment, no death penalty, then such a kind of trial will be done as a summary trial, in which you have to inform the magistrate court for the same, or the any competent authorities who think fit so for trial, the summary trial, they can do the summary trial. Or if any simple kind of summon trial or the warrant trial, with due permission of the court, the summary trial will be done. And the summary trial is done by the chief judicial magistrate, chief metropolitan magistrate, or any other court permitted by the high court. And summary trial is done in the sort of cases in which there is a theft or the chori of whatever the 2000 rupees or the less than 2000 rupees, stolen property you receive which having amount 2000 rupees or the less than 2000 rupees, or you're supposed to conceal or the dispose of the property which is belonging to any case, or the which is stolen property of less than 2000 rupees or 2000 rupees, or if you are going to looking of within particular matter, or the house trespass, or the peace breach, or the provoke or abet for the attempting of crime to the opponent party. In this sort of 7 type of crime, the summary trial will be done. And likewise, all these things are there in the summary trial. Apart from the same, if we finish over there, you should have to look after one of the important part, in which this kind of courts are there as per the hierarchy: Supreme Court, High Court, District or the Session Court, Magistrate courts are there, and some sort of special courts are there. Likewise, Prevention of Money Laundering courts, PMLA courts are there, NIA courts is there, NDPS courts are there, POXO courts are there, or SC/ST courts are there. Likewise, depending on the scenario to scenario, it totally special court. If any new act is comes over there, or they establish over there, enact over there, then special court will be there for that particular act. So it totally depending on the different kind of scenario. So this kind of sort of information is there for the all kind of sort of criminal procedure or the stages. So likewise, many things are there, but we don't go that much of deep. Likewise, if any things we miss, let me cross check all this point. So we'll close for the same. Okay, in the examination of witness, examination in chief, cross-examination and re-examination should be done. Closing of evidence should be done. Likewise, in the forensic case, you just have to take the screenshot. Many things are there. fingerprint test, DNA, ballistic analysis, toxicological test, forensic pathology, including the postmortem and all. Other question on the documentation examination, digital forensic test, forensic entomology, forensic anthropology, or forensic serology. Many things are there you can use as an investigation. So such a kind of things are there. If we'll go through the sort of things or revise the things, we gone through the crime, we define the crime on seriousness, non-serious, available, non-available, cognizable, non-cognizable, compoundable, non-compoundable. Then we gone through the information of crime in the form of FIR or the NCR. If no FIR, SP, we have to move the application to the SP, then after the magistrate. Then after we gone through the jurisdiction of the court, means taluka, tehsil level, magistrate level courts, or the session level courts, high court and supreme court, or the metropolitan court. After the investigation, if person got arrested, he can apply for the regular bail. If he have information he might be arrested, he move the application for the anticipatory bail. If the investigation will be done, police wala have to collect evidences, witnesses, confession, panchanama, expert opinion, move the application for the concluding of evidences as a charge sheet maybe, or only without investigation as a concluding of investigation report. If the charge sheet will be done, we will get the opportunity to argue on the charge sheet. If there's some sort of information comes out of the argument, then finalization of charges will be done, then the trial will be going on. If any no information of crime or the sections or the charges are done, then the person will be discharged from that particular case. If trial will be done and whatever the kind of evidence are placed by the prosecution side, or the examination of witnesses will be done from the prosecution side, and if court thinks fit so there is no any sort of information received by the prosecution side to prove all these offenses or the crime, then police wala whatever the evidences they place or the witnesses they place, court have a full right to dismiss all this case at the first hearing of trial or the first sort of trial, because there is no any such evidence, so there is no any use of to ask the opponent party or the accused to go for the trial. If trial is done by the prosecution side, if court think fit so some fewer kind of or the minimum kind of charges are there, then court will ask the opponent party or the accused whether you are accepting all these charges. If that person is going to accept, he'll directly punish if any small charges are there. If court think fit so, he'll get the opportunity to place his evidences or the accused. If in the next parallel way, if that accused or the offender wants to proceed with the trial, he have an option to proceed with the trial. If even though that person who is the accused is accepting his offenses or the crime he done, but that offenses are likewise for the death penalty or the life imprisonment or the most of serious offenses, and even though he is accepting, but he'll get the compulsory trial, he have to do the compulsory trial, means after the conviction of him no party can claim or the no person can claim he won't receive the proper, he won't get the proper chance to argue on the charge sheet or to argue on the trial. Many things are there. That is why if any serious kind of offense, even though accused is going to accept the charges, even though he'll get the mandatory things to trial the matter, so likewise all these things are there. Then after the trial the matter, both the parties will get the equal opportunity to argue on that particular evidences, and the judgment will be done. So sort of information are there likewise in the criminal things. So these kind of things are there in the criminal part. If you have any question, you can ask us now, and who are the present over there, you just have to write it down, your all names. So it will be help us to distribute the certificate within 1 week. So everyone who are just joining this session, you just have to write it down your correct spelling of name, not in the group. You have to write it down here in the Google Meet. Okay, and meantime, if you have any question, you can ask for the same regarding today's scenario only. Courtpractice.com is also conducting the detailed sessions on the court practice to teach the civil and the criminal court practice or the family court practice. If you think fit so, you can learn. You want to learn the same, so you can learn. All this information we are going to put in the group. The courses are for the 30 days. Along with the same, you will get a recorded session of that or some sort of notes for the same. So many things are there. All this session we are going to do in Hindi, English and Marathi languages. So if you think fit so, if you are suitable for the same, or even though you think fit so, your college wants such a kind of free of cost session, you can convey the same message to your seniors or your professors or the principals of this, or you can inform us regarding the same. We will try to arrange some sort of session for your college. So it totally depends on you. You just have to write it down your own name with the correct spelling if you want to receive your certificate. Otherwise there is no any sort of distribution of certificate. Okay, just write it down. लिखना स्टार्ट कीजिए सेम इसमें कमेंट सेक्शन में. We will cross check the information with the sort of data you fill at the time of registration. Okay, कोई किसी का कोई सवाल है आज के सेशन को लेके? We know all these things are getting more and more because we don't have that much of sufficient time. So we just have to finish all this thing. Okay, तो might भी आपको बोर हुआ होगा इन सारे सेशंस में, तो आई एम हार्टली रिग्रेट फॉर द सेम. ठीक है, कोई लिखना नहीं चाहता है इन्फॉर्मेशन या फिर मुझे दिख नहीं रहा है, क्या हो गया है? एम आई ऑडिबल टू यू? अच्छा, राइट इट डाउन योर नेम if you want to receive your own certificate for the all this boot camp. You have a 5 minutes, you can write it down for the same, or if you have any sort of question you can ask us regarding your general things or regarding the criminal things or the family things or the any kind of information regarding the practice. Okay, कि किसी का कोई सवाल है? अच्छा चलिए, किसी को सर्टिफिकेट नहीं चाहिए तो अच्छी बात है. What, sir?
For the certificate thing, where do we have to message you?
In the comment section only, here in the Google Meet. Because you join the session, why we have to give the opportunity to the people who are not there in session here meeting?
Sir, and you will be sharing the notes, like whatever you...
We will cross check all this recording if whoever the person who attended all the session. Okay, so we will go through the same. Whoever the person attended the session, we will share the information of notes to them. If any person who just join and just skip the meeting, there is no any use of the same. So we have all the recordings of last sessions, so our team will go through the same. We'll cross check whoever the persons attended all the session for the all time, so we'll do for the same. Only one person wants the certificate. Okay, no issue, it's up to you only.
So actually the session was very good. It was totally knowledgeable. It was not boring.
Okay, thank you for the same.
Yesterday's session actually I
Actually, in such a kind of session, we won't get that much of sufficient time to go in depth, but it is okay for the law student. It is sufficient to get at least that much of information. When we were in the law student, even after the completion of law, we don't had that much of information regarding the stages and all. So after the completion of LLB, whether it is 5 years or the 3 years, you're supposed to think that you don't have that much of knowledge, or you think fit so you're in some different medium or the different field, because whatever the conventional education is there in the law, it is totally different from the practical things, and all the things are done in the parallel way only. That is why might be you people confused for the same. Okay, all the things are done with the, okay, not an issue, only 5 people are there, not an issue. We are just noting it down all the 5 names and we'll distribute for the same. Okay, अगर किसी को और चाहिए information, so you can inform us.
Sir, I just have one question.
What's the
I just have one question.
S?
Sir, while choosing the field, to pick a field whether of criminal, how do we see it?
Wait a moment. I think there is some issue with the speaker, so let me join the earphone, so it will be better. हाँ, you can ask me now. Yes, sir. Okay, okay. Do one thing. You are the law student now. Are you law student now, right? So what you have to do? You have any previous experience of internship? No, don't don't go directly for the criminal or the family or the civil or the sort of field. You have to join the internship for minimum 2 to 3 months or the 6 months, first for the criminal, then for the civil, then for the family, likewise whatever comes to you. Then you have to take the proper knowledge within the 6 months or the minimum 6 months. Okay, if you are convenient with the 3 or 4 months of internship, then it would be okay. Then what things will be happened within that sort of 6 months of civil or the criminal or the family, you will get the proper information whether you are made it for the civil or the criminal or the family or the another kind of field. Why it is so? Because you don't have to waste your 3 or 4 years only in the one field, for the civil only or for the criminal only or for the family only or for the labor only. No, you don't have to do that actually. You have to dedicate your time for the 6 months at least. And dedicated time means you don't have to do the time pass over in that particular period. You have to read all this file, you have to read the case laws, you have to go through all the basic information. Just wearing the black coat or the black pants or the black shoes, that doesn't mean you have become advocate. Many advocates are there, they are having all kind of things, they are having a 7 years 10 years of experience, but during all these courses we realize that the information you gain in the practical field is totally exceptional and depending on yourself. If you are the smart, you are going to learn all this procedure within 1 month, 2 months, or the 6 months. But if you are the dumb kind of things, dumb is not a proper word, but the sort of information I have to inform you, that is why I am using that. What people are doing, the people are doing only the things, they just join the internship. Why they join the internship or they join the law office? Because they have not the alternative for the same. And if relatives are there or the family members are there or the friends are there or the colleagues are there are some burden on their head, If they are not visiting the court regularly, police, whatever the family member or the relatives are going to taunting them for the same, and that is why they are just only visiting the court. And during all this visiting the court, they are also join some kind of internship or the law offices, and what they are doing, they are just following the seniors. What they are doing, they are just following the seniors. They are just keeping their bags or the files, और वो क्या होता है, उनके बस पीछे पीछे भागना, वही काम होता है उनका। और उन्हें बहुत अच्छा लगता है कि वो एडवोकेट बन चुके हैं, लेकिन दे आर हैविंग जीरो नॉलेज फॉर द सेम। वाई जीरो नॉलेज? क्योंकि whoever the senior you are going to join, they are not that much of knowledge for the same, and they are not convinced that knowledge to you. If they are not convey that knowledge to you, might be due to some busyness, or many times senior think it so. If they are going to teach you all sort of information or the cases or the stages, then might be in future you are going to take down their clients. If the senior is taking 50,000 for one client, if you are going to separate from that law office or the senior, then you can take the case only for the 5,000 or the 10,000, because you know there is no any use of taking the 50,000, because there in only small stages are there. So likewise things are there happen. That is why many times senior are not going to teach you properly. Might be few seniors will get, but most of the seniors are likewise only. So that is why during this internship period, what you have to do, whatever the relationships are there, whatever the emotional attachment of there from that office or from that college colleagues or the seniors, is totally useless. Because in the law field, if you are going to establish yourself as an independent advocate within the sort of span of period, then and then you will be surviving the law field. Otherwise not. Why it is so? Because last years, or I think 2 years or the 3 years back, during the corona period, one of the survey was done by the eminent university of foreign, and they received the information. Whoever the first generation advocates are there or the second generation advocates are there, after the 3 or 2 years of practice, they are in mindset, they just want to change the field, because there is no any use of doing the law practice. Why it is so? Because they are not having that sort of knowledge to how to run the cases and all. And why it is there? Why such a kind of survey was done, and why such a kind of information is there in that particular survey? Because there is no any sort of books or the informations are there which combine to us to give the information of all the stages in collaborative manner. And even though we are not that much of self-sufficient to go for the same, to collect all this information, many informations are there on the internet. If you wanted to become a good advocate, you can do the internship, you can read the books, you can watch the online videos, you can join the seniors, you can join the big law firms. All the set of informations are there, but it totally depending on how smartly you have to behave over there. If you are going to smartly behave over there, then it would be better for you. Otherwise there is no any use for the same. And why it is so? Because even you are going to spend lots of time in the internship or the law offices, but for learn all these things, it is sufficient to spend some 3 months, 4 months or the 6 months maximum to get how the knowledge will be done, how the cases will be done, how the procedure will be done. It is sufficient for the same, but it totally depending on how to receive that information. And then after 6 months, if you done the internship for the 6 months in the civil, then do the internship for the next 6 months. Don't attach with the first law firm or the seniors. You just have to shift the offices or the internship. then you have to go for the criminal field, then you have to go for the family, then you have to go for the corporate law or the labor, it depending on you. And within span of 2 years, you will have a proper information for which field you made up for. आप सिविल के लिए बने हो, क्रिमिनल के लिए बने हो, या फिर बने ही नहीं हो लॉ फील्ड के लिए. Because many people are just wasting their time to just follow the seniors from one court to another court, from court to office, office to court, or the office to home. Only they are doing this thing for the 2 to 3 years. Then after they realize they are not made up for the civil things, they are not made up for the criminal things or the family things or the corporate things. Then why you have to realize all these things? Don't be regret for the same in future. That is why you have to smartly act. If you are the law student now, just start internship randomly. Many platforms are there. You can do the internship or the different kind of courses. At least you should have to gain some sort of knowledge that giving you the information regarding the how you have to practice in the court of law. Otherwise it's totally useless for you. What the people are doing, they are doing. But if you also going through the same pace, there is no any use. Because in this particular internet era or the online era or the digital era, there is no any things. If you are going to waste the time, you have to lose your 2 to 3 years. If you are going to smartly act, you will move forward for the same. If otherwise, what will happen after the 2 or 3 years? You will realize that no, I have to try it for the criminal part of things, because I think so criminal people are earning more, family people are earning more, corporate advocates are earning more. I will only do the drafting part. I will only do the convenience part. So many things are there. So why you are just limiting yourself only to the one field? Just behave like unlimited things, and you just have to join the random internship. Whether they are giving you the certificate or not, whether they are giving you the whatever the traveling charges or not, or the whatever the kind of stipend or not, just do the internship. मेनी टाइम्स यू फील्स लाइक दैट, अरे मेरा तो लॉ फील्ड हुआ है लेकिन मेरे ऑफिस में जो क्लर्क है उसे मुझसे ज़्यादा पता है. मेनी टाइम्स यू फील दैट because that person or that guy having some practical experience. But if you are not belonging to some eminent university or the colleges, there is no any mute court, even though there is no any sort of opportunities will get. Or if you are belonging to some sort tier 2 or the tier 3 cities or the taluka tehsil, there is no any prominent courts are there, or even the courts are there, there is no any smart kind of practices going on, only some sort of cases are there. Likewise, to make a sort of certificate for the legal hairs and all, only such a kind of small cases are there. Many times you realize that your seniors are having some setting with the police station or the courts, totally depending on the random things. So you have to take the experience of all this field. Then after 2 or 3 years, you just have to finalize what field is there and in which field you have to enter. Because many times are there, we realize that for the single bail application, person is taking 50,000, and you are running the civil cases since for 3 years or the 4 years, but you are not earning that much. But the bail wala application people is just earning 50,000, 1 lakh rupees only for the 2 to 3 days hearing. So many things are there. So that is why you have to take the experience of all many fields, then you can think on the same. And if you are the first generation advocate, किसी बात की दिक्कत नहीं है, all this information available on the internet. You can join the online courses apart from the regular law practice. If you are the ladies, many online informations are available. And because of आपके पास कोई सीनियर नहीं है इस वजह से कोर्ट में जाना छोड़ दोगे, ऐसा नहीं करना है. यू रेगुलरली विजिट द कोर्ट, ट्राई टू अंडरस्टूड द थिंग. बस काला कोट पहनो और जाके बैठो कोर्ट में कि क्या चल रहा है, पता लगेगा आपको. Once you realize all these stages, at least you can imagine what is going on that particular court. Then it will be easy for you to take the decision for the same. And in this law field, early 2 to 3 years or the 5 years, even though there is no any money, if you are the luckiest lucky one, then you can earn the money. Otherwise, not. Because you have to gain the knowledge. I am not giving any kind of fear or the dangerous act to you, but all this is the practical things only. And there is no any person who is going to spoon feed you for the same. और आप ऐसे बंदे भी नहीं हो जिसके मुंह में चांदी का चम्मच रहा होगा, नहीं है ना. और फर्स्ट जनरेशन एडवोकेट या फिर सेकंड जनरेशन एडवोकेट, यू हाउ टू टेक दैट मच ऑफ रिस्क. अदरवाइज कोई यूज़ नहीं है फिर लॉ फील्ड में आने का. आप 2 4 5 साल वेस्ट करोगे और फिर बाद में फील्ड छोड़ दोगे. क्योंकि अगर आपकी एज, इफ़ यू आर नॉट लेडी और इवन यू आर द लेडी और यू वांट टू डू द इंडिपेंडेंट प्रैक्टिस, क्या होता है अगर आपका 3 years 5 years का कोर्स भी हो, 5 years के लिए ठीक है, लेकिन 3 years का कोर्स तो आपकी एज हो जाती है लॉ फील्ड ख़त्म होने तक 25 26 27. और विद इन 3 4 years में अगर आप फिट नहीं होते हो लॉ फील्ड के लिए, आपकी फैमिली आपको सपोर्ट नहीं करती है, तो देयर विल बी अ बर्डन ऑफ मैरिजेस, बर्डन ऑफ सोसाइटी. बिकॉज आपको ऐसा लगेगा कि भाई आपका दोस्त जिसको जो लॉ फील्ड का नहीं है, आपका दोस्त जो पढ़ा लिखा नहीं है, ही जस्ट रनिंग वन ऑफ द शॉप एंड अर्निंग इन लैक्स. एंड एज एन एडवोकेट यू हैविंग अ 3 years 5 years का डिग्री, बट यू आर ओनली सॉर्टिंग आउट फॉर द क्लाइंट्स. यू वोंट हैव अ सिंगल क्लाइंट्स नाउ. और जो भी क्लाइंट मिलेगा उसे फ्री में केस चाहिए, फ्री में एडवाइस चाहिए. सो व्हाई यू हैव टू गिव ऑल दिस इंफॉर्मेशन टू देम फॉर द फ्री ऑफ कॉस्ट. जो भी पर्सन मिलेगा आपको 2000 में 5000 में काम करने के लिए बोलेगा, ऐसे कैसे चलेगा. सो दैट इज़ वाई इफ़ यू आर डूइंग 3 years वाला कोर्स, तो अभी से जाग जाओ या फिर अल्टरनेटिव ऑप्शन देखना स्टार्ट करो. मैं डरा नहीं रहा हूँ आप लोगों को, बट दिस इज़ द प्रैक्टिकल रियलिटी. बिकॉज 2 3 साल बाद आप 30 साल क्रॉस कर जाओगे, अगर आप कमा नहीं रहे हो तो फिर देयर इज़ नो एनी यूज़. आई नो, आई रियलाइज दैट कि भाई कमाई नहीं होती है उस टाइम तक भी, क्लाइंट नहीं मिलते हैं. सब डिस्ट्रिक्ट लेवल, तालुका तहसील लेवल में भी क्लाइंट नहीं है, डिस्ट्रिक्ट लेवल में भी नहीं है. इफ़ यू आर देयर इन मेट्रो सिटीज देन इट विल बी ओके, ठीक है वहाँ, लेकिन बाकी के सिनेरियो में नहीं है. अगर सीनियर ठीक नहीं है तो भी आप सीख नहीं पाओगे. तो डोंट वेस्ट योर टाइम इन द लॉ फील्ड. बिकॉज सिविल जो केसेस है, सिविल केसेस में यू हैव टू हैव स्पेंड मोर टाइम. सीखने के लिए ज़्यादा टाइम लगेगा, क्योंकि वह वंस द केस इज रजिस्टर्ड इन द मंथ ऑफ जैन, वो केस बोर्ड पर आएगी अप्रैल मई में, थोड़ी बहुत प्रोसीजर होगी दिसंबर तक. इस तरीके से 1 साल तो चला गया. सो व्हाट यू लर्न फ्रॉम द सेम. सो दैट इज़ आई एम टेलिंग यू, डू द इंटर्नशिप फॉर द मोर देन 6 years ओनली, मोस्ट ऑफ द 6 years. अदरवाइज छोड़ दो उस ऑफिस को, दूसरे ऑफिस को ज्वाइन करो. बस पैसे मिल रहे हैं, मेरे घर के करीब है, ठीक है, मेरे रिलेटिव्स है, वो क्या सोचेंगे, मेरे घर वाले क्या सोचेंगे कि चेंज कर दिया, चेंज कर दो. डोंट थिंक अबाउट द पीपल. लोगों को कुछ लेना देना नहीं होता है लॉ फील्ड को लेके. लोगों को बस इतनी ही खुशी होती है कि वो किसी दिक्कत में आएंगे तो आप उनको फ्री में एडवाइस करोगे, उतने ही उनके पास एडवांटेज है. आपके दोस्त है इसीलिए वो आपको बेल एप्लीकेशन का 2 लाख देंगे, ऐसे कुछ भी होने वाला नहीं है. रिलेटिव्स होंगे तो उनका बस यही रहेगा कि नहीं भाई मेरे रिलेटिव्स हैं एडवोकेट, वो फ्री में केस करेंगे मेरे लिए. और वन ऑफ द मोस्ट इम्पॉर्टेंट थिंग, डोंट स्पेंड द टाइम इन द ट्रैप ऑफ रिलेटिव्स एंड ऑल, और द केसेस इन द रिलेटिव्स और द फ्रेंड्स. दोस्तों के एक टाइम पे चल जाएगा, लेकिन रिलेटिव्स के केसेस के ट्रैप में मत पड़ना, क्योंकि उनको पता नहीं होता है कि लॉ फील्ड 2 तरीके से काम करती है. कोई भी बड़ा से बड़ा क्यों ना एडवोकेट आ जाए, इज़ नॉट गिविंग एश्योरिटी कि आपके फेवर में ही केस आएगा. अगर समझो आपने किसी रिलेटिव्स का केस लिया है और आपके फेवर में नहीं आता है केस, तो आपका भी रिलेशनशिप ख़राब होगा उस रिलेटिव्स के साथ। और रिलेटिव्स इतने दूध के धुले कोई होते नहीं हैं, वो 10 जगह पे जाके बताएंगे कि मैंने इनके लड़के को केस दिया था लेकिन उन्होंने हरा दिया है मुझे। तो जो माउथ पब्लिसिटी होगी वो निगेटिव वे में होगी। वो समझ के नहीं लेंगे कि क्या गलत हुआ है उनके केस के साथ, कि उनके एविडेंसेस ठीक नहीं थे, कि वो कुछ झूठे थे, नहीं। और आपका रिलेशनशिप ख़राब हो सकता है, आपके फैमिली के रिलेशनशिप ख़राब हो सकते हैं। तो इट वुड बी बेटर कि जस्ट एस्केप फ्रॉम दी आपका जो रिलेटिव्स वाले केसेस होंगे उसमें। दोस्तों के लिए ठीक होता है, कुछ टाइम चल जाता है, लेकिन बाकी के रिलेटिव्स के केस में नहीं चलता है। वो 10 जगह पे जाके बताएंगे लोगों को। अगर बहुत ही क्लोज रिलेशनशिप है तो ठीक है, फैमिली का समझ में आता है, दे कैन अंडरस्टूड द सिचुएशन, बट अदरवाइज नहीं करना है। तो ऑल सच ए सॉर्ट ऑफ थिंग्स आर देयर। सो यू हैव टू क्रॉस चेक ऑल दिस थिंग कि आप किस फील्ड के लिए बने हो। तो इसी तरीके से एक तरीका है जो तय कर सकता है। और जब भी आप लॉ ऑफिस ज्वाइन करोगे 6 मंथ के लिए, तो ऑफिस के पॉलिटिक्स में मत पढ़ना है, नहीं ही पढ़ना है कि भाई वो लड़की मुझे पसंद है तो उसके साथ ही मैं कोर्ट में जाऊंगा, वो लड़का मुझे पसंद है तो उसके साथ ही मैं कोर्ट में जाऊंगा, उसने ये कह दिया है, उसने वो कह दिया है। डोंट डू इन दैट पर्टिकुलर ऑफिस पॉलिटिक्स वाला ट्रैप। इतना टाइम नहीं है हमारे पास कि उस ट्रैप में पड़े रहे। कोई किसी को पूछता नहीं है 6 मंथ के बाद। अगर आपका लॉ फील्ड भी कंप्लीट होता है तो आपके लॉ कॉलेज कंप्लीट होने के बाद कोई एक दूसरे को नहीं पूछेगा, ना प्रोफेसर काम आएंगे, ना कोई रिलेशनशिप काम आएगा। और अगर आप लॉ फील्ड में हो, आपका रिलेशनशिप बना भी होगा, तो आपके पार्टनर को अभी से बोल लो कि भाई थोड़ा टाइम लगेगा सेट होने में, 2-3 साल लगेंगे, वरना दूसरा देख लो। प्रैक्टिकल थोड़ा सा होना पड़ेगा। अगर आपके पार्टनर्स जो भी है वो उतने सपोर्टिव है आपके लिए, तो इट वुड बी बेटर आप उनको कन्विंस करो, आपकी फैमिलीज़ को कन्विंस करो शादी को लेके जो कुछ भी है, और कमाई को लेके। और ट्राई करो कि जल्दी से जल्दी आप सेटल हो पाओ, क्योंकि लॉ फील्ड एक ऐसा फील्ड है, कमाई का कोई भी जरिया फाइनल नहीं है। आपको पास केस आएगी ही, ये फाइनल नहीं है। और जब तक आप रिजल्ट देते नहीं हो लोगों को, तब तक कोई नहीं आएगा आपके पास। इसीलिए बोलना सीखो। बोलना मतलब यू शुड हैव अ सम काइंड ऑफ सॉर्ट ऑफ कम्युनिकेशन। वो जो भी कम्युनिकेशन होगा एक बेटर वे में लोगों को लगना चाहिए कि हाँ भाई एडवोकेट है। आप गाली दे के बात कर रहे हो क्लाइंट से, आप जो भी क्लाइंट है उसके इर्रिस्पेक्टिव उसके एज क्या है, उस तरीके से बिना एज देखे बात कर रहे हो। आप समझ ही नहीं पा रहे हो कि केस क्या है, आप समझा ही नहीं पा रहे हो क्लाइंट को कि केस क्या है, तो फिर इस तरीके से काम नहीं चलेगा। अगर आपको नहीं आता है तो सीखो, इंग्लिश नहीं आता तो इंग्लिश सीखो, वर्नैकुलर लैंग्वेज नहीं आती तो वो सीखो। ट्राई टू अंडरस्टैंड ऑल दिस थिंग ना। मेनी टाइम्स क्या होता है, आप इंग्लिश में बात करो कि आपका काम नहीं होगा, लेकिन आप 2 बातें आपके वर्नैकुलर लैंग्वेज में, लोकल लैंग्वेज में भी बात कर लोगे ना, तो काम हो जाएगा, क्योंकि लोगों को अच्छा लगता है ऑल इस ऑफिस में। तो अगर आप लॉ फील्ड को एज ए चैलेंज लोगे तो फिर वो कन्वीनियंट रहेगा आपके लिए, अच्छा रहेगा। लेकिन आप लॉ फील्ड को एज अ बर्डन लोगों कि भाई कुछ ना कुछ बर्डन है, ये हो गया वो हो गया, तो फिर कुछ नहीं होगा, आप कुछ नहीं सीख पाओगे। जैसे कि हमने विद इन 6 और 7 सेशन सिविल और क्रिमिनल का एटलीस्ट आउटलाइन कवर किया है। इतना आउटलाइन समझने के लिए लोग 3-4 साल लगा देते हैं, बिकॉज इन द लास्ट सेशन वी हैविंग सम ग्रुप ऑफ एडवोकेट्स विच हैविंग सम 7 years 10 years का एक्सपीरियंस, और वो कोर्स करने आ रहे हैं क्योंकि उन्हें बेसिक ही नहीं पता है। उन्हें पता ही नहीं कि स्टेजेस कैसे फॉलो अप होते हैं केसेस में, उन्हें पता ही नहीं कि मेंशन कैसे करना है। वाइट इज सो, क्योंकि उन्होंने वही काम किया था, एक ही सीनियर पकड़ा है, उसी के पीछे लगे हैं सालों के सालों, 2 साल लगा दिए, 3 साल लगा दिए। उनको लगता है कि मेरे सीनियर बहुत अच्छे हैं। भाई अच्छे होंगे, उनके घर पे अच्छे हैं, दे आर नॉट गोइंग टू फीड योर फैमिली एंड यू। तो इस तरीके से ही आपको चलना पड़ेगा, प्रैक्टिकल थोड़ा सोचना पड़ेगा, अदरवाइज कुछ फ़ायदा नहीं है। ठीक है, और कोई सवाल है आपके? सॉरी मैंने आपका ज़्यादा टाइम लिया हो तो। जी जी सर बोलिए। टुडे इज़ द लास्ट। विद इन 1 वीक्स आ जाएगा, जितने भी लोगों के नाम है उसको मिल जाएगा, बाकी के लोगों को नहीं मिलेगा जो नहीं है अवेलेबल सेशंस में। जी, तो हमारे वी हैव अ रिकॉर्डेड सेशन, वी विल गो थ्रू द सेम। तो जो भी रहेगा उनके नाम दिख जाएंगे जिन्होंने ज्वाइन किया था, और वो बस ज्वाइन किया था ऐसे नहीं, जो रुके भी थे सेशंस के लिए, तो उनको मिल जाएंगे। सो दिस आर द थिंग। क्योंकि देखिए, इवन हमें सर्टिफिकेट डिस्ट्रीब्यूट करने से कोई दिक्कत नहीं है, ठीक है, सर्टिफिकेट तो मिल जाएगा, लेकिन उसका कुछ यूज़ नहीं है, उसमें कोई सीरियसनेस मेंटेन नहीं रहेगी। इवन वी आर सेइंग कि भाई हम आपको सर्टिफिकेट भी देते, लेकिन उसका कोई यूज़ नहीं होगा कहीं पे भी। वाई इट इज़ सो? क्योंकि अगर आपको नॉलेज ही नहीं है उस फील्ड का तो कुछ फ़ायदा नहीं है। नॉलेज इज़ अ मेन पार्ट फॉर द सेम। तो लॉ फील्ड ऐसे है, आप नई रिसेंटली ज्वाइन भी किया होगा, आपके पास नॉलेज है तो यू कैन अर्न हैंडसम अमाउंट। अगर आपके पास नॉलेज नहीं है, आपको 4-5 साल का एक्सपीरियंस हुआ होगा, तो कुछ यूज़ नहीं है फिर उस बात का कि आपके पास नॉलेज नहीं है, तो यू आर नॉट गोइंग टू अर्न एनीथिंग। जी, सर्टिफिकेट का क्या पूछ रहे हो आप? हेलो? ओके, नॉट एन इशू, हमें कोई दिक्कत नहीं है उसके लिए, बस जो क्राइटेरिया था मैं बता रहा हूँ आपको कि किस तरीके से वो सिलेक्ट होगा, ठीक है। एनीवन हैव ए क्वेश्चन अपार्ट फ्रॉम दिस सेम? सर्टिफिकेट और नोट्स के अलावा पूछिएगा, क्योंकि वो तो कहीं ना कहीं से भी आप खरीद भी सकते हो। अगर लॉ फील्ड के रिलेटेड कुछ पूछना होगा तो यू कैन आस्क मी, ठीक है। तो अब पूछने की कोशिश कीजिएगा। अगर फ्यूचर में कोई पेड कोर्सेस आते तो वी विल कॉन्वे द मैसेज इन द ग्रुप। अगर आप करना चाहते हो, किसी और स्टूडेंट को करना होगा तो आप बताइएगा। इसके अलावा फिर आपको या फिर आपके कॉलेज को अगर इस तरीके के सेशन करवाने होंगे तो यू कैन इन्फॉर्म देम। विल डू 1 और 2 डेज़ का या फिर 3 डेज़ का बूट कैम्प हम अरेंज कर सकते हैं फॉर द फ्री ऑफ कॉस्ट, ओनली फॉर द लॉ स्टूडेंट फ्रॉम योर कॉलेज। तो आपके सीनियर से बात कीजिएगा, तो आपके लिए अच्छा भी हो जाएगा, क्योंकि अभी आपका तो एग्ज़ाम ख़त्म होगा, तो आप तो मामा के गांव जाने वाले नहीं हो, ये आप छोटे तो नहीं हो अभी कि मामा के गांव जाएंगे, अंकल के गांव जाना है, ऐसा तो कुछ होगा नहीं। तो इट विल बी बेटर यू कैन स्पेंड योर टाइम। एंड वन एंड लास्ट थिंग आई हैव टू इन्फॉर्म यू, द इलेक्शन आर गोइंग ऑन, ठीक है। इलेक्शन आ रहे हैं, सोच समझ के वोट करना है, अंधों की तरह वोट नहीं करना है। एज अ एडवोकेट सारे चीज़ों को परखना है, ठीक है। डोंट डू ऑल दिस सच काइंड ऑफ थिंग्स कि भाई रिलीजन के बेस पे करना है, कि भाई बहुत अच्छा लग रहा है कोई बंदा उसके बेस पे करना है। लास्ट 10 years आई एम जस्ट फ्रैंकली स्पीकिंग, मेरा ये राइट बनता नहीं है, लेकिन एज अ एडवोकेट आई हैव सम सॉर्ट ऑफ थिंग्स टू द सोसाइटी, दैट इज़ आई एम टेलिंग यू। लास्ट के 10 years टोटली वेस्ट हुए हैं, तो डोंट वेस्ट द फ्यूचर। लास्ट के 10 years में जितना कुछ हमने देखा है, बिकॉज आई एम बिलोंगिंग टू the particular person who done his master in the law field, not in the law field only but in the pharma field only. After the pharma field I shift towards the law field, but उसका कुछ यूज़ नहीं है। why it is so? क्योंकि मार्केट इतना सैचुरेट हो चुका है जिसमें आपको इक्वल अपॉर्चुनिटी चाहिए। इफ़ एनी गवर्नमेंट इज़ ओनली डूइंग द सॉर्ट ऑफ थिंग्स विच इज़ ओनली टू स्प्रेड द हेटरेट विदाउट एनी डेवलपमेंट, तो फिर उस बात का कोई यूज़ नहीं है। बिकॉज आपकी ये लास्ट जनरेशन रहेगी जिनके पास नॉलेज है कुछ लॉ का, वरना आप ये सारे सेशन अटेंड नहीं करते। जैसे कि कल परसों का कोई एग्जांपल है, गलगोटी या कोई यूनिवर्सिटी है दिल्ली की, वहाँ के कुछ सॉर्ट ऑफ स्टूडेंट जो कोरोना में पास हुए, लॉकडाउन में कुछ पास हुए होंगे, वेन सॉर्ट ऑफ रिपोर्टर दे आस्क द क्वेश्चन टू यू, दे आर नॉट इवन रियलाइज व्हाट दे आर डूइंग। तो इन सारी चीज़ों में मत पड़ो, टाइम ही वेस्ट होगा। बाकी के लोग 10 साल वेस्ट कर चुके हैं, जो लास्ट टाइम जिन्होंने 14 में इलेक्शन में वोट किया होगा, नाउ दे आर रियलाइजिंग आफ्टर दे आर क्रॉसिंग द 30+। जब सोसाइटी का डंडा पड़ेगा, जब घर वाले पूछने लगेंगे कि कमा रहे हो नहीं कमा रहे हो, तब आपको रियलाइज़ होता है कि यू जस्ट वेस्टेड द टाइम फॉर द सेम। तो इसीलिए पॉलिटिक्स के चक्कर में मत पड़ो। जो भी है वो लॉ फील्ड में अगर आपको करना है, अगर आप लेडीज़ हो तो घर में बैठे मत रहो, घर में बैठे भी हो तो लॉ रिगार्डिंग इन्फॉर्मेशन लो। और वन थिंग्स आई हैव टू इन्फॉर्म द लेडीज़, घर वालों के चक्कर में आके शादी मत कर लो। पहले सोचो कि आपको करना क्या है। शादी होने के बाद आपकी लॉ फील्ड में नहीं रह पाओगे उतने सॉर्ट ऑफ थिंग्स है। एज आई नो यू आर लुकिंग फॉर द सम पर्सन हु इज़ गोइंग टू टेकिंग केयर ऑफ आफ्टर यू, बट उसके लिए ना एक कॉन्शियसनेस आपको मेंटेन रखना पड़ेगा कि भाई किसके साथ शादी करनी है, किसके साथ नहीं करनी है। क्योंकि मेनी टाइम्स वी रियलाइज कि जो भी एडवोकेट्स है, वेदर दे आर लेडीज और द जेंट्स, मेनी टाइम्स दे आर सफ़र विद द डिवोर्स वाला केसेस। और तो एक बार अगर आप खुद का डिवोर्स हो जाए, क्योंकि आपको राइट्स वगैरह पता होते हैं, तो वो काफ़ी इनसफिशियंट होता है कि किसी ऐसे पर्सन के साथ रहना जिसे लॉ फील्ड की कोई नॉलेज ही नहीं है। आपको लगता है कि भाई मैं क्या कर रही हूँ इस पर्सन के साथ, तो मेनी टाइम्स योर माइंड विल बी चेंज। तो वॉट एवर द डिसीजंस आर देयर ना इन योर लाइफ, टेक इट वाइजली, टेक योर ओन टाइम। और एज अ लॉ फील्ड आप कोई भी रिलीजन से, कास्ट से बिलोंग नहीं कर रहे हो। यू हैव टू गेन ऑल दिस सॉर्ट ऑफ इंफॉर्मेशन, नॉट ओनली फ्रॉम द लॉ फील्ड, फ्रॉम द साइंस फील्ड, इकोनॉमिक फील्ड और द सोशल फील्ड। सब नॉलेज लेना चाहिए, जिसके आपका क्या है, एक ओपिनियन बिल्ड होना स्टार्ट होगा। अगर आपका ओपिनियन बिल्ड होना स्टार्ट होता है तो आपको कोई रोक नहीं पाएगा, क्योंकि आपके पास उतना नॉलेज आ जाएगा। आप लॉ फील्ड में ना सही किसी और फील्ड में जा सकते हो। अगर 2-4 सालों में भी आपको लगता है कि आप लॉ फील्ड के लिए नहीं बने हो, तो डोंट वेस्ट योर टाइम, जस्ट एस्केप फ्रॉम द लॉ फील्ड। दूसरी बहुत सारी फील्ड है, आप पढ़ा सकते हो, सोशल मीडिया का ज़माना है, आप कोई इन्फ्लुएंस वीडियो बना सकते हो, मेनी थिंग्स आर देयर। तो डोंट रेस्ट्रिक्ट योर सेल्फ फॉर द वन फील्ड ओनली। देर आर लॉट्स ऑफ अपॉर्चुनिटी, रिमोट अपॉर्चुनिटी भी है, ऑन साइट जाना ही ऐसे ज़रूरत नहीं है। लेडीज़ हो तो आप घर से भी काम कर सकते हो। फाइंड आउट द अपॉर्चुनिटी फ्रॉम द फॉरेन कंट्रीज़, घर पे बैठ के फॉरेन का काम करो। राइट या फिर आप ड्राफ्टिंग का काम कर सकते हो, ड्राफ्टिंग सीख के रखो। कॉन्ट्रैक्ट ड्राफ्टिंग बहुत पैसा चार्ज करते हैं कॉन्ट्रैक्ट ड्राफ्टिंग वाले भी। तो डोंट रेस्ट्रिक्ट योर सेल्फ फॉर द लॉ फील्ड, सॉर्ट ऑफ इंफॉर्मेशन लो, तो ऑल सच थिंग्स आ गए। ठीक है, कुछ क्वेश्चन होंगे तो 2 मिनट में आप पूछ सकते हो, अदरवाइज हम वाइंड अप कर रहे हैं सेशन। अच्छा लगा आप लोगों से बात करके, जिन्होंने भी रेगुलर सेशन ज्वाइन किए। हम हमारा कुछ तो कंट्रीब्यूशन सोसाइटी के दे रहे हैं, खुशी होती है इस बात से, क्योंकि मैं खुद एक फर्स्ट जनरेशन एडवोकेट हूँ, तो आई रियलाइज द पेन ऑफ यू। तो ऑल द बेस्ट फॉर योर ब्राइट फ्यूचर। आपको कभी भी लगता है ना कि आपको कोई हेल्प चाहिए, नोट्स के रिगार्डिंग हो, कोई प्रैक्टिस के रिगार्डिंग हो, तो वी ऑलरेडी हैव अ नंबर इन द व्हाट्सएप ग्रुप, वहाँ से आप कांटेक्ट कीजिएगा। माइट भी हम कॉल अटेंड नहीं कर पाएंगे, एक व्हाट्सएप मैसेज कर दीजिएगा। ठीक है, जब भी मैसेज देखेंगे आपको रिप्लाई करने की कोशिश करेंगे। तो आपको ऐसा फील मत होने दीजिएगा कि आपको कोई सपोर्ट नहीं कर रहा है लॉ फील्ड में। किसी से शिकायत करने की ज़रूरत नहीं कि आपको किसी ने सपोर्ट नहीं किया होगा। ठीक है, तो आज के बाद अगर आपने ये सेशंस ज्वाइन किए होंगे तो आपको ये फर्ज बनता नहीं कि आप किसी के सामने शिकायत करो कि आपको कोई हेल्प नहीं कर रहा है लॉ फील्ड में। ठीक है, तो किसी भी तरीके की इंफॉर्मेशन यू नीड, इन्फॉर्म अस, वी विल हियर टू हेल्प यू आउट। एज अ माइट भी आप हमसे छोटे हो सकते हो या फिर हमसे बड़े भी हो सकते हो, जो भी हो। आपको अगर लगता है लॉ फील्ड में आपको कुछ करना है, कुछ हेल्प चाहिए, तो यू कैन आस्क फॉर द सेम। ठीक है, थैंक यू ऑल ऑफ यू फॉर ज्वाइनिंग ऑल दिस सेशन। अच्छा लगा आप लोगों से अपना 1 वीक का टाइम स्पेंड करके। अगर किसी का सवाल नहीं है तो हम जस्ट वाइंड अप करते हैं। ठीक है, वॉट एवर द सर्टिफिकेट एंड द नोट्स विल बी देयर, दे विल डिस्ट्रीब्यूट विद इन 1 वीक आफ्टर द क्रॉस चेकिंग ऑल दिस थिंग्स। ओके, ठीक है, चलेगा। कोई सवाल नहीं है आपके तो ऑल द बेस्ट फॉर यू। ठीक है, थैंक यू।